Hey viewers, welcome. It is very important to look at the African legal system, whether it is a reality or it is work in progress. We have treated legal systems in other presentations, and I do recall that independent African states adopted and adapted colonial legal systems. This one is not in dispute. And where is the African legal system? Is there something we can refer ourselves to as an African legal system? If it is not, the so-called African customary law. Is there something we can refer ourselves to as the African legal system if it is not what colonial regimes referred to as the native law, indigenous law, or traditional law, or, for the lack of better terms, primitive law? These are some of the questions in the academic circle and also in the scholarship that looks at law as science and from the already discussed and debated schools of thought, the natural law school of thought, the positivist school of thought, the realist school of thought, and the historical and sociological school of thought. This is how I do believe that we can approach our understanding to get or to unearth the African legal system. But this is backed by several studies that have been carried out by scholars, law scholars, jurists, and those who are known as Africanists, those who are mostly interested in discourses pertaining to African knowledge. However, still, it is very significant to look at the African knowledge, whether it worth our time, and how the world is looking at the African knowledge. The African knowledge has been missing in action. So many African educated elite have departed from the African approach to knowledge, and most importantly, the African approach to the legal knowledge, legal science. Many jurists who are in Africa and beyond the African boundaries have explored the African knowledge of law using the Western lenses, Western theories, Western concepts, but too little has been done to enable the legal literature to capture the African legal values, the African legal culture, the African legal traditions, traditional dispute resolution mechanisms. This has been what I call a negligence, but justice system and the people themselves have not been forgiving. We know that the society is changing. We cannot really be reasonable to look at the African legal system in the past or the African legal system in the customs that are no longer in use, and people since have developed some dislike when it comes to certain practices that were kept in certain traditions, certain groups that sometimes are referred to as customary groups. But let us unpackage this, let us flesh it out and make it clear in this kind of academic explanation and approach. The clarity and the sense that it should make to all of us is based on the people. That is the indigenous knowledge. The question of the people is very significant. Even in the Banjul Charter, the African Charter on Human and People's Rights puts people within the African knowledge of human rights. We still find people in the Constitution of the Republic of Kenya of 2010, Article 1, that provides for the sovereignty as sovereignty with the people of Kenya. The word people still is revisited in other documents to look at that communal concept that only belongs to the African people. This is something I consider a huge contribution when it comes to the understanding of the African legal system. The Western theories have presented individualism, individual approach to rights, individual rights, whereas the Eastern Bloc of Europe, that is the former Soviet Union and the likes, proposed the emphasis on socio-economic dimension. The Africans, rather, have proposed the cultural approach to human rights. This is again helping us to engage ourselves with the traditional law, the law of the people of Africa. This is what we call and consider the African knowledge that today we refer to as indigenous knowledge. It is the knowledge of the people of Africa, the knowledge of non-professionals, non-academic, people who still live and maintain what I consider the residual law. This is the living customary law in Africa. It explains to us all that it is a system because it has scientific knowledge of the law as well as communal and universal concepts and ideas that the African people have practiced, have applied, have used from time immemorial. This should not be misunderstood or misrepresented using colonial prejudice that we find in certain colonial principles that have been considered outdated and backed by some stereotypes and prejudice, such things like repugnancy, such things like practices that are against the general morality. But all in all, the African people have got something to be proud of, their diversities, their cultures, heritages. This is how we look at legal education in the new curriculum, education that is socially inclusive, that does not leave anyone behind. Everybody matters when it comes to the justice system. Everybody matters because we have equality as human beings, and also we are holders of certain cultural rights, social rights, and traditional rights. It is from this purview that arguably we can say that we are absolutely cultural right holders, and the teaching of the African traditional systems or the African traditional legal system is very appropriate and in line with the market demand, in line with the search of knowledge that creates impact on the society and on the individuals. It is in this perspective that I would like once again to say, quote and quote, that African legal system and African traditions value so much today more than ever before and more than what has ever been seen since the colonial time and the departure of the European imperialism from the African continent. Thank you for watching. Peter here, University of Nairobi School of Law, Kisumu campus. It is all about law and the society. Bye, and remember to subscribe.